Thank you, Mr. Chair, and this is my first opportunity to ask a question on part 2 of the bill. It relates specifically to section 6, where it talks about, after subsection 1611QDV, inserting particulars of phases that the authority is able to rule on. And I understand there have been questions on this, but my questions are different because they relate specifically to the scope. And so this is about the scope of the authority's powers, particularly in the word, in relation to the word, the particulars of those phases. So my questions are really, does that relate to how payments are made and the timing of the payments? What about confidentiality, and what about any impacts or legal status of non-disclosure agreements that are signed? What kind of relationships would those NDAs have if they were already in existence with the authority's scope as it relates to the particulars of the phases? And I'm thinking here about what kind of rights are available, because currently most of the rights are limited to de novo rights, but is this something different? I'm thinking about what happens if something goes wrong and what kind of appeal rights would be available. So would this relate to another form of tribunal or court? Will it rely on precedents of the casework that has already happened under the authority's scope in the existing legislation, or does this have a new level of scope and therefore no precedent to inform it? So quite technical questions, but really important given that we're in new territory here and we want to understand the scope of the authority in this subsection.
Mr. Chair.
Mr. Chair, in response to the member Lawrence Sunan, who asked about clause 51 and if we can't have reviews, what are the alternatives and will it increase judicial review action? The question is not actually about the change in part 2, it's about the removal of the ability to include review clauses in settlements, which is part of part 1, which we did debate at length. And as I've covered many times, settlements will be able to be re-raised after 10 years.
Rachel.
Okay, Laura, how would you like to answer that?
So in response to section 6, subsection too many letters and numbers, we don't have enough judges to go over cases. So women are just screwed. Sorry, ladies, you got fucked over for some helicopters. Happy Mother's Day. Hashtag I'm not a lawyer. I think
Or a minister.
It's like one of those TV shows. Just so you know, these are not legal offerings. I'm just telling you what I know, but I'm not a lawyer.
Not a lawyer. I mean, this bill is so cool, it didn't even require a regulatory impact statement or a select committee. Oh yeah, we only voted to get in one extra judge. So yeah, ladies, the backlog, I don't know, find a way to deal with it.
Yeah, you are right. Yeah.
I don't know, just battle each other. Have a battle royale or something. I don't know, fight for the judge.
Yeah.
But I saw the post that Sam Uffendale put up the other day. I think it was the first day of debate. And according to him, women would be too busy dealing with womanly problems like menopause. So they can't focus on things like, equitable pay outcomes and menopause at the same time.
I don't know. Menopause tends to make women pretty angry. So maybe he doesn't want to go down that route.
He might have already had an angry woman outside his electric office on Friday.
Yeah.
Well, he is from Tauranga. Chances are there were a lot of angry menopausal women there.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.